All right, we're back on Morning Line. Thanks for joining us. Nick Leonardo with us, talking some of the big legal cases. One story I wanted to ask you about is many people across the region, it's been more than almost 2 years now, come April, the Joe Clyde Daniels case. And it's scheduled for trial. Another one we may well do gavel to gavel if it happens in August. And I've got a story that I'm going to have more on tonight, but I broke it this morning. Crystal Daniels called me from her jail cell, and we had a recorded phone conversation. And I've talked to her before, but now her take is, Crystal, you'll recall, among other things, and it was testified to by the TBI agent, said that she, the night Joe Clyde disappeared, came out of her room, heard a ruckus, looked and saw her husband Joseph, who's charged with homicide, standing over Joe Clyde with his fist up, beating him, and that he looked up and more or less threatened her, saying, "Get back in your room." That's kind of the testimony that's on the record. She's not charged with homicide. She's charged with reckless endangerment.
Or aggravated child abuse.
Or aggravated child abuse, rather. I'm sorry, yeah, aggravated child abuse. So now in her conversation with me, she's telling me that it was coerced and that she's not standing behind what she told the TBI, and that, you know, that statement is not something she is going to go with as they head to trial. So when you keep having people changing their stories and saying, "I said it, but I didn't mean it," or "I was coerced," like her husband recanted his confession, what do you think that means, especially in a case where they have very little physical evidence, and having that statement from her likely would have helped their prosecution's case?
You know, first of all, I think it's a credit to you and the work that you do that you're able to get these stories and these people call you. But you know, that's not odd for things like that to happen. And of course, she's not charged with murder; she's charged with aggravated child abuse. And so I can only imagine that when the police initially interviewed her, they would probably say things to the effect of, "We know he did it. You don't need to go to jail for the rest. You just tell us the truth. You know, you won't do a lot of time in jail. We know he did it. We know he did it." And you know, maybe they were able to get her to agree or to some sort of false confession, or maybe what happened. And so we don't know what really took place. And I'm sure those interrogations are videotaped, okay? And they, you know, that's something that could be shown at trial. But it's a real mess when you start changing your story like that. And of course, you know, it's even further a mess, the fact that she's got $1 million bond on aggravated child abuse. I mean, that's not something that you would see $1 million bond on. But again, until they get a body, they're going to continue to play one against the other in an effort to get a conviction. The state is.
So what do you think it means, though? I mean, between Joseph apparently having told several stories, the father, and recanting, and now her, how can you believe anything any of these people say when they keep, "Well, I said it and I didn't mean it, I was coerced," and they go back and forth? I mean, it just seems like they're chronic liars. I mean, and it's a fact that they're a liar in the sense that they lied at one point because they recanted. Now they may claim that they were coerced, but how do you believe anything any of them say?
Well, and that's exactly the nightmare for the defense counsel in this case. I mean, you know, if they were to take the stand, they can't be forced or compelled to testify against themselves if you're charged with a crime, but if they were to take the stand in their own defense to try to tell their side of the story, they're going to eat them alive with all of these prior stories. You know, which one's true? I mean, even though that wasn't under oath, we don't know what to believe from the Daniels parents here. But again, they don't have to testify because the state's got the burden of proof and has to prove them guilty beyond a reasonable doubt. And in this case, we don't have a body. We know that he's gone, but I mean, without a body or without some serious confession, you know, that's stuck and that has, you know, that they've maintained, I don't know that at this point, from what I've heard, I could find them guilty beyond a reasonable doubt. We know the little boy's no longer around, but did they kill him? You know,
no, there's no body.
Question is, you know, can they prove it?
Okay, and with regard to Crystal, you know, taking it back, just like with Joe, I've been told just because someone recants doesn't mean it just goes away. It can still be presented by the prosecution to say, "Look, originally when this all went down," now he's had a bunch of time to think about it, but he told us this, and they can still present the confession or Crystal's statement to the jury and let them decide whether they believe it or not.
Well, I mean, that's exactly right, especially if they testify. I mean, you know, there could be pretrial motions where the judge says you can't show this interrogation or you can't get into these things. But if the criminally accused takes the stand in their defense, then they could very easily open the door to have those, you know, come back in. And another thing that could have happened is maybe she's changing her story because the state's not giving her a good deal. You know, she went along with the police to begin with, thinking she was going to get a good deal. She's still in jail on a $1 million bond. They're not getting any movement. The offer to her is 25 years at 100%. So she's not going to play that game anymore. I mean, so maybe she's, you know, aligning herself more with her husband now.
And is there, you always hear, and you know, you've told me in the past that no defense team, you know, objects to a delay. But Does a defendant have a right, and she told me another thing that I'm going to include in the story, that she's frustrated with the fact that she's been locked up now for nearly 2 years with the trial postponed again until August, and she is going to demand a quick and speedy trial. What does that mean?
Well, so she's got the right to demand a speedy trial, okay? So because a lot of times there are loss of witnesses, there could be loss of evidence, police officers no longer work there, one of your witnesses has died potentially, okay? So she could invoke her right to a speedy trial, but again, that's not something that that you're very successful on from where they're sitting, okay? Because I believe one of the continuances was at the hands of, at their request, right? And so it's hard to holler about a speedy trial when you're the one asking for a continuance at least once or twice. It seems like maybe there was new defense counsel that got involved or something
maybe that
a year
was
or
it.
so
And
ago.
it may have been brought by they're being tried together, and that came from the father's side, perhaps, her husband.
Well, and I mean, you can't help but think, though, the longer this goes, the state's trying to sweat each other out. I mean, trying to figure out where this body is, they're trying to make the case that they think they have, while these people are incarcerated, because there isn't a body. I mean, the way this story's been leaking to the media, if they really had something, we would know.
And so you think the state still possibly, it's not an open and shut case?
No, absolutely not. I mean, it's like the Perry March case. I mean, there wasn't a body. Now, there was a conviction based upon his actions, but again, we don't know, what confessions have been made and what all has been said, and I think a lot of it's going to come down to what is in those videotaped interrogations, and if whether or not defense counsel has moved to suppress those because they were, coercive,
Wow. Okay, it's going to be interesting. And again, that trial's scheduled to go in August, which, we may as well consider doing gavel to gavel too, provided the judge allows it, because so many people have followed that. Let's go to Ronnie next. Ronnie, good morning. What's on your mind?
I got 3 short questions.
Okay.
One, I don't believe that a police should shoot to kill. I mean, he can shoot his legs to get him from running. And second, I don't believe they should convict somebody just on just false evidence. And one person told another person, a cop said, run so I can shoot you. Why do they say that?
Okay, well now, I don't know about your second point. Of course, you shouldn't convict someone on false evidence. I don't know what evidence he's referring to. As far as shoot to kill, we get that a lot, and you know as well as I do. What do your law enforcement officers tell you if they get to a point where they feel they need to use deadly force and use their weapon? They're not shooting for the head, which would be a fatal shot. They're not shooting for the leg. They shoot central body mass because? Well,
because that's where your vital organs are, and that's probably the easiest thing to hit. But I mean, if you're going to use or employ a firearm as a police officer, that is the use of deadly force. And so your life, has to be threatened, or the life of someone else has to be threatened. And so that's why they're trained to shoot to kill instead of just to shoot someone in the leg. Now, we see that sometimes where an officer may, they have the right to do that, but maybe they do shoot someone in appendage. But if you're pulling your firearm out, that's because you are in imminent fear of serious bodily injury or death, or that of a third party. And so if you're going to employ that firearm, the use of deadly force is just that. It is shoot to kill, and that's how it's trained. That's why we have tasers, and that's why that is the last thing that a police officer would ever do, would be pull his service weapon out or her service weapon out and employ it in the field.
Yeah, now practically speaking too though, and you're exactly right, if you really wanted to shoot to kill, I mean a headshot, that's going to take care of it. And officers very rarely shoot people in the head. They'll hit people here, and you're right. There's organs there that will kill you. But the point being, just practically, you're nervous. You're pulling out a gun. You feel your life's in danger. You're aiming at the largest target. And in the event that your aim is not true, you may not hit here, but you may catch a head. You may catch an arm or a leg. You're not aiming for a small appendage that's more likely to miss.
Well,
it's that simple.
You
I mean,
may
it makes
only
sense.
have one shot.
You want to hit what you're shooting at, and your best shot is that central body mass, because it's the largest target on the body.
Well, and you may only have one shot to neutralize that threat.
Right,
I mean,
that too.
And if you were to miss a headshot, I mean, that could turn and lead to the death of a police officer as well. So, I mean, that's exactly why they go for the central body mass.
Gotcha. All right, let's go next to George. George, good morning. Hi, George.
Right.
What's on your mind?
I got about 2 questions. The cop that shot that boy running with a gun, why don't they think that man can shoot a gun while he's running? Because you can stick a gun behind your back and pull the trigger, and they're getting that cop for murder. And like them, the Waffle House shooting, they let him sit in there. They should have done killed him, put him to death. And they want gun control. We'll start killing some of these people that do his damn shootings for no reason. That's all I got to say.
Thank you for your call. Well, Travis Ranking in the Waffle House shooting will be scheduled for trial at some point, and I don't think they're seeking the death penalty, just like they didn't with Emmanuel Sampson. They couldn't kill him at that point. Remember, he was disarmed by the hero in the Waffle House. Now, as far as, is that going to be part of the case? He's right. All right.
That's exactly what you're going to hear
right?
the defense
Hambrick's
say.
running. He has a weapon. Now, the question is, will you see it in the video? Is it what Delkey perceived? As he's running, could he have been going like this? Now, I have not seen an indication of any point where he was running what we've seen, where he's like that. Right. But is there enough to make him think, oh, he's about to turn that gun on me?
Well, I mean, if Mr. Hambrick had a knife, case closed. Okay, but when it is a firearm, I mean, George is exactly right. I mean, that he could turn, or he could put the gun behind him and direct it towards the direction of the officer, or maybe Mr. Officer Delkey was thinking that Mr. Hambrick was engaged in the felony reckless endangerment. Okay, by running with this gun in his hand, and thereby he had authority under our state statutes to neutralize that threat or to shoot him.
Does the state statute, before we go to break, include that he could have perceived that, all right, he may not be a threat to me, but he's running that way. There could be children playing out there, or there may be a couple of my officers coming around the other side that are going to be confronted by him. I need to neutralize this threat before he encounters these other people. Could that count? In my line of thinking, that's like shooting someone because you think something's going to happen and you don't really know it.
Or what if he gets up there and says, I saw two little kids that were 50 yards.
Well,
I mean, we don't know what he's going to say. That's why we can't rush to judgment. We know that Officer Delkey killed Mr. Hambrick. Okay, right. And that's a very tragic thing. But again, we need to reserve judgment until we see the facts or hear the facts that surround this video, because we don't know what everyone's going to say. In this video, we all know what we see, but it's the facts that surround the video that are going to, again, lead to a acquittal or a conviction.
Take a break on that note. We'll come back with a little bit more in our final segment with Nick Leonardo. More of your calls if you'd like right after this.